All right, joining me now, Adam Kraut from the Firearms Policy Coalition with big news. Adam, I think I just felt a disturbance in the universe starting in California. Talk to me.
Hey, Tom. Well, thanks for having me back on. And yes, I believe there was a huge disturbance in the force. On Friday, Judge Benitez released his opinion in our assault weapons ban case, which was formerly Miller versus Becerra, but now it's the new AG subbed in Miller versus Bonta. And he found that California's assault weapons ban scheme is unconstitutional.
So California has had a ban on so-called assault weapons for, 32 years?
I believe that's correct. I think it was 89 when the first version of their assault weapons ban
32
passed.
years. All right. And then, of course, it's been expanded and, it's gone deeper and included more things. And, basically they never met a gun they couldn't or wouldn't try to ban and just keep expanding. And, of course, the whole idea is, for those who listen to this know, there really is no such thing. There's no definition for assault weapon, which is perfect if you just want to make it include as much as you can. You just keep shoving more stuff into this thorny political term.
Correct, and that's exactly what was, at the core of this lawsuit. When you look at how they define the term assault weapon, you do this, and California has done it based on a features test. So if your gun is a center fire, semi-automatic rifle that has some of these features or any of these features, then we deem it to be an assault weapon and you can't have it. In fact, I guess inverse would be true, that if it's a semi-automatic, firearm, that's a center fire cartridge that lacks those features, that's okay. So at the end of the day, we're talking about the same exact firearm, just lacking certain things attached to it, and somehow the state believes that made those firearms less useful for criminals to use, and in reality, it just deprived ordinary individuals of firearms for self-defense that were suitable for that purpose.
Who is Judge Roger Benitez? Because this thing is masterful, this ruling.
So he is a district court judge. He was actually a George Bush II appointee. He was appointed and I think ultimately confirmed in 2004. And he's an interesting individual if you look at his history, because his parents actually fled Cuba when Fidel Castro's regime was starting to take over. So he's kind of seen firsthand, or has certainly heard stories firsthand as to, government gone wild, I guess would be the best way to describe it.
Right.
Exactly one of the reasons we have the Second Amendment. So, he's also the judge that released the opinion dealing with California magazines, I think in 2017, so about 2 years ago. That's up on appeal at the Ninth Circuit still. But he's an individual, if you read through his decisions, and I would encourage all of your listeners to do so, especially the most recent ones, because it was written in a way that anyone can understand it, which I think was his point. You'll be able to follow the logical chain as to why, here are what the facts are, here's what the law says, and here's the rationale as to why California's ban was unconstitutional.
So it's really not full of a lot of legal jargon that you're trying to figure out what's he talking about. I mean, it really is something that you could sit and just say, I'm going to read this tonight. It's 94 pages. And at the end of it, not only will you be impressed with, his concepts and what he's putting out there, but you'll actually learn a lot about the AR-15, about gun rights, about the Second Amendment, and what it means when something is unconstitutional.
Yes, I think that's perfectly put.
Okay, well, I mean, I like the fact that he compares the AR-15 with the Swiss Army knife. He says this is just something that is useful. It's a tool. It's used for a lot of different things. And of course, that phrase, which is exactly how he started the whole thing, I think is driving some of the gun ban lobby people crazy.
It's funny how a metaphor has become the focus of everybody's opinion. I mean, I think anybody over the age of 30 and potentially even younger, if they should have heard at some point in their life that comparing an item to a Swiss Army knife just means it's a versatile item.
Right.
I'm not sure why everybody, on the anti-gun side is losing their minds over it, but fine, if that's what they want to concentrate on and be upset at, that works for me. We got other things to do, and if they want to be distracted by, a metaphor, then so be it.
Sure, exactly. Now, clearly, this case is set up. I mean, it's targeting going right to the Supreme Court, but you got to go through probably a three-judge panel on the 9th, and then maybe en banc if we figure it's going to go the same way as the magazine ban case. But all of this is designed to drive toward the Supreme Court. Toward what end? What are we looking for at the end of all this?
Well, so you're exactly right. So this case was designed in-house about two years ago, 2019. We worked with a number of groups to get this into, litigation, finding plaintiffs, things of that. And the whole point of it was, if you look at all the other assault weapons ban cases that have been done, those in the Fourth Circuit, First Circuit, even the Ninth Circuit, none of them went to trial. This is the first one that went to trial, and what that allowed us to do was build a record with the factual and the evidence to go up on appeal to the Ninth Circuit. As you said, it likely, will go in front of a panel and then go en banc, driving it toward the Supreme Court. And the whole goal is setting this up so that the Supreme Court can come back and say that these are common arms in use for lawful purposes, and they are protected by the Second Amendment. And they said exactly that in Heller, for what it's worth. The lower courts have just seemingly found ways to, sidestep and duck and bob and not actually address that head on. But I think with the factual record that was developed in this particular case, unlike any of the others that have been previously litigated, I think this one is set up much better to get that point out there and have the court weigh in on that.
I want to go back to that for a second, because in the Heller decision, 2008, the Supreme Court said you cannot ban guns which are in common use. The lower courts have pretty much just thumb their noses at that. And so what this says is we're going to establish that the AR-15, in fact, semi-automatic rifles are, in fact, in common use. Therefore, according to the Heller decision, which the Supreme Court has already said, you can't ban them. It seems to me, Adam, that this has the potential, if it goes to the Supreme Court, they say, yes, we agree, you can't ban these. All of these so-called assault weapons bans evaporate as a result of this.
That would be the idea. Yes, exactly. That none of them. If you look at the reasoning and rationale in any of the other circuits, including the Ninth, that have so far upheld these bans, they've all found ways to kind of sidestep that, and they distill it down into their two-part test, and then they say intermediate scrutiny, and they apply intermediate scrutiny light, and they say, well, the government's interest here is more important, and therefore it carries the day. That their ban is reasonably tailored to fit that. And here, again, when we go back to what Heller says, Heller said that even though certain handguns were still available, a ban on any handguns was unacceptable. Just because there were alternatives didn't make the ban on those few acceptable or constitutional. So, again, at the end of the day, that's what we're hoping to get out of all this once we go on up. And the way the Ninth Circuit's been, there have been some okay panel decisions out of it recently. Now, the en banc is going to be the real question at that, and then where we go from there.